We've got a quorum already, so I think we should start. This is the meeting of the Constitutional Affairs Panel. Please invite the administration in. Agenda item number 1, information papers issued since the last meeting. Only one information paper has been issued, and that is a letter from Mr. Kenneth LEUNG indicating that he would like to withdraw his membership in this panel. Item 2, items for discussion at the next meeting. So we'll discuss this item after the officials have been seated. So I would like to welcome Mr. Lau Kong Wah, the Undersecretary for Constitutional Affairs, Mr. Gordon Leung, Deputy Secretary for Constitutional and Mainland Affairs, PAS for Constitutional and Mainland Affairs, Ms. Helen Chong, Ms. Dorothy Chang, Senior Assistant Solicitor General, Department of Justice, and Mr. Vernon Low, Senior Government Counsel, Department of Justice. So can I ask the administration what items you wish to raise for discussion at the next meeting? Yes, Chairman. For the meeting in December, we are proposing 2 items. First of all, voter registration exercise 2015. In July this year, we passed, or the electoral legislation miscellaneous provisions ordinance was enacted, and so we hope that in the next cycle of voter registration we can advance the starting date. We hope that we can brief members on our work and our publicity programs at the panel's meeting in December. And of course, we'd like to listen to members' views on the arrangements. Secondly, concerning the follow-up measures on an investigation initiated by the Ombudsman. As members may recall, in March this year, the Ombudsman published a report in relation to an investigation into the access to information situation in Hong Kong. And in that report, there are 12 recommendations. We promptly took follow-up action on the report, and would like to brief members on our work. Ms. Emily Lau. Chairman, I would like to know when the next meeting will be held. 15th of December, Monday, 2:30. I want to ask a question about the report on public sentiments in relation to the political reforms or the constitutional reforms. In fact, during the last sitting, over 10 members were not able to ask supplementary questions. In fact, some suggested that there should be a discussion today, but it seems that we're not going to have this discussion today. So I want to know whether we're going to have a special meeting to discuss this matter. Undersecretary, please. Yes, Chairman. After the last sitting, Ms. Emily Lau raised the issue with me. We subsequently had a discussion in-house concerning the report. We are now in the stage of collecting public views. And also we are collating the information we have, and at a suitable time, we'll release the report. And if members think it is necessary, then of course there can be a discussion in the panel. Ms. Emily Lau, I think you need to listen to the views of LegCo and the views of the public. You shouldn't just work behind closed doors and then complete the report and then release the report to the public. I hope that before you write the report, you can come to LegCo to consult members first. So can you come to this panel at an early stage of your work? Under Secretary, you told us that you were collecting information on the report. So have you considered when you will have to listen to the views of LegCo members? Yes, Chairman, thank you. There are statements issued, and then there are comments expressed, there are signature campaigns, and there are also results of opinion polls. So we will collect all such information that has arisen since the 31st of August. So after we have collated all the views, we will write the report and release the report to the public. Ms. Helena Wong, I'm very disappointed. Last time I said that the panel must be consulted. This is the Constitutional and Mainland Affairs panel, and I think it is necessary for you to obtain our input in this exercise. So, Chairman, may I suggest that a special meeting on the matter be convened as soon as possible? Last time we said that such a meeting or such a discussion should be arranged, and I'm disappointed that we still haven't got any progress. And concerning the multi-party platform, that was a promise made by the CS4A when she met the Federation of Students. So we want to know how many parties will be represented on the platform. Is LegCo one of the parties? And when will this platform be set up? So I want to ask whether the CS4A or the Bureau intends to talk to members again before the second stage of public consultation starts. Helena Wong, I want to clarify one point. And at the last meeting of the panel, no one mentioned the report on public sentiments about constitutional reforms because the idea was proposed after our meeting. But then, because the minutes of the last panel meeting did not mention constitutional reforms. Now, the report on public sentiments was first, or the idea was first raised at the meeting with the Federation of Students, and our meeting took place before that meeting. But last time we said that the Secretary should come back to update us on the latest progress. But I just want to clarify that at the last meeting we didn't mention or the report on public sentiments. All right, it doesn't matter, Chairman. I hope that next time we can formally discuss this issue. Last time we discussed the second round of public consultation. All right. So can the Undersecretary tell us which parties will be included in the multi-party platform? Undersecretary. Chairman, I just want to say that we welcome views to help us put together the report on public sentiments. And secondly, concerning the multi-party platform, to look at constitutional reforms beyond 2017, the CS4A put forward the idea in the light of public concerns. But then we are still in a stage of exploring this idea, and we are willing to explore with all sectors, including LegCo members, the detailed arrangements. I think an urgent task before us is to start the second round of public consultation. And this public consultation exercise is for all sectors in the community, not merely for the parties concerned on that multi-party platform. And this consultation exercise relates to constitutional reforms for 2016 and 2017. But then as to the way forward beyond 2017, there will be this platform, but we haven't really got the concrete details yet. Members' suggestions and views are of course welcome. Thank you. Mr. Wong Yong-man. I have nothing to say. Okay. Mr. Leung Yu-chung. Chairman, thank you. I hope that a meeting can be arranged for us to discuss with the administration the structure of the multi-party platform. The Undersecretary said that he wanted to listen to our views, but we want to know the development after the 31st of August. So what sort of comments are you collecting, and how are you going to present these comments in the report? So I hope that they will tell us the framework or the outline for this report. And then concerning the multi-party platform, we would also like to have an idea of the administration's preliminary thinking. Anything you would like to say at this stage? No? Undersecretary, Ms. Claudia Mo. Yes, thank you, Chairman. Concerning the report, who, where, now, when, how, I think we need to know all these details. I understand that this is an administrative act. There is no need for you to get the approval or the blessing of LegCo. But then we hope that we can coordinate the work of the executive and the legislature. Though you may decide not to heed our advice, we still want to know what the content of the report is going to be.
And also with the Administration Commission, the Public Opinions Program of the Hong Kong U to do a detailed opinion survey on the umbrella movement. Undersecretary. Mr. Chairman, as I said, I have already given you an account of the progress on formulating the public sentiments report. Ms. Mo said something about commissioning other people to do an opinion survey. We have no plans to do that at this stage. Please speak into the microphone. We cannot hear you clearly. She cannot hear you clearly. Please speak into the microphone. Ms. Ann Chang. Thank you, Chairman. I'd like to ask the Undersecretary. In the past, when the CE filed reports with the central authorities, did he have to also give the report to the Legislative Council for us to scrutinize? I'd like to clarify that point first. So this time around, as far as I know it, the public sentiments report would form part of the report from the CE to the central authorities. Does it have to come to the LegCo for discussion before it is submitted or after submitted, or is it necessary to take it here to LegCo at all? Undersecretary, what's the convention? Chairman. The member mentioned certain CE's report. I was not involved in that part of the work, so I have no view on that. But regarding this public sentiments report, it is going to be put together by the Task Force on Constitutional Development. We will be assisting the work of the task force. I heard concern expressed by some members on the public sentiments report. You say you are collecting information. Why don't we include it as an item for the next meeting? If members have views on that report, members can talk to you, and if by that meeting you have already reached a certain stage in the formulating of the report, you can also let us know. There will be this item as well on the 15th of December, that is the next meeting. What about the multi-party platform? I heard from the Undersecretary just now that if there will be a second round of public consultation, the platform will be there. It will involve all sectors, everybody. It will be totally open. It's not just multi-party. Is that right, Undersecretary? Chairman, two things. One, legislating for 2016 and also consultation for 2017. We will have that open platform. But maybe Mr. Leung is referring to post-2017. We don't have anything concrete for that. We are now exploring into that with different parties. So can we ask them to give us a paper next time about their thinking at the moment? Let's see if we can provide, you can provide a paper for the next meeting. Mr. Wong Yuk-man, I did not want to speak, but I have to speak up. After the dialogue between the administration and the students, the administration said there would be a public sentiments report that will be filed, and also there will be a multi-party platform. You say it is very important, but how important it is? It is just empty talk. You seem to think that something important has been promised. See, ask Mr. Lau Kong-wah. They don't even know what they are going to do. They say the paper is in their mind, but their mind is empty. They don't even know what to do about these two promises. About multi-party platform, Mr. Lau Kong-wah has already said that the second round of public consultation on the constitutional development is already a multi-party platform. You took them for real, but they are not doing anything on those. Well, whether they do it or not is none of our business. I mean, to be frank, they are just engaging in empty talk. So legislators don't play their game. They are just making empty promises. And I think it's really laughable. I did not want to say anything, but then after listening to them, I find it even more laughable. So what were those promises? They were just giving lip service to it. And then in the second round of consultation, they will say they collect public opinion and they say, this is the public sentiment, so we will do some adjustments. That would be more practical, but I'm going to object to it. I raised constitutional by the people, but many people abstained from voting on the motion. Thank you. Well, you could have saved your breath. Undersecretary, anything from you? If not, that is the arrangement. Item 3 on the agenda. Results of the public consultation on disqualification of candidates with unserved prison sentences and other related matters and proposed way forward. We have two papers. One is Legislative Paper CB-2 267/14-15 and the other paper is bracket 04 prepared by the Secretariat. Undersecretary, can you take us through the paper, please? Thank you, Chairman. The paper was originated from two JR cases in 2012. There were two persons who were sentenced to imprisonment, but they have not served out their prison term, and they were appealing against judgment and the penalty, and then they wanted to stand in the election. According to the ordinance then, they could not stand in the election, and then they took the cases to court and they won the judicial review case, so we had to revise the law. So in the exercise, we had to amend the relevant ordinance, and we also reviewed ordinances concerned. So this is a report to members. In fact, before this meeting, we consulted the community in July. The results are included in this paper before members. Last month, we consulted the panel on certain matters in this exercise. Now we have collated this report. We are going to submit the report to you, and then we will explore the way forward. We are making certain proposals. Number one, if someone has broken the law and he is appealing against the case, but he has not served any prison term, no matter at what level the election will be and no matter at what stage the appeal is being undertaken, we will allow the person to stand in an election. This is the major adjustment or amendment. We heard some reservations about this proposal during the consultation exercise. it was said that there could be uncertainty that would affect the election. But we gave the proposal certain consideration because the judge said that this was unconstitutional. And also it is an appeal stage, and that person is not deprived of his liberty. He is not serving out the sentence of imprisonment. So we propose that amendment. Secondly, if the prison term is being served and that this person cannot stand in election, we would maintain that arrangement. During consultation, we heard views for and against this proposal. The Hong Kong Bar Association and others talked about proportionality. But then there were other views saying that we should preserve the arrangement because that person is in custody, and if that person stands in election, there will be problems of uncertainty and fairness. So we propose to preserve the disqualification of that particular person in elections. These two elements will also apply to district council elections and also rural offices. Another major proposal was about the disqualification of members of councils. At the last meeting, we discussed with members the disqualification of DC members and LegCo members when the relevant members have broken the law. If a member has been convicted and is serving a prison sentence, and however there is an appeal having been lodged, we can see that the waiting period is about 14 days or 28 days, depending on the level of court. So even if a person is serving out a prison sentence and an appeal has been lodged, we would allow for suspension of disqualification until the appeal is heard and decided. So it is 14 days or 28 days, depending on the level of court. At the last meeting, two members raised two views. The first one is that if in Hong Kong we say it is 1 month for LegCo members and 3 months for DC members, in other words, members would be disqualified if they are sentenced to such prison terms, then if we look at overseas jurisdictions, the penalties are quite different, and the penalties would not be the same in severity. And members asked whether overseas convictions should be exempted so we can have fairness. We went back and thought about this point, and our view is that this would not be appropriate because we should still comply with laws of that place if we are overseas. And also if we do a law for law comparison, it may not be appropriate. So for the sake of consistency and also to preserve the solemnity of elections, we will preserve the situation where if there is a conviction, whether it is in Hong Kong or overseas, then we should still preserve the 1 month prison term for LegCo members and 3 month prison terms for DC members. And so these members will be disqualified. And then the second view expressed by members was that if there is a conviction overseas and the appeal period is not the same as that in Hong Kong, what are we going to do? We agree that we should look at this point. We looked at the appeal period in other jurisdictions, and they are so varied. So we are going to amend the relevant section to say that no matter what the appeal period is like overseas and what kind of appeal it is, we will go for the shorter period. In Hong Kong, we have 14 days or 28 days. So even if you have a longer appeal period overseas, we will only allow 28 days, the longest. We like to have some consistency. Chairman, that is a simple account of what we are going to do. Since in 2015 we have DC elections, I hope to listen to members' views today so we can carry forward legislative amendments that are required. Hopefully, we can make it in time for the election next year. 2 members have so far raised their hands, 3 now, and they are Helena Wong, Ann Chang, and Raymond Chan. 5 minutes each. Mr. Wong Yok-man. Thank you, Chairman. The administration always says that they respect the rule of law, but if you look at how they treated the Leung Kwok Hong and SJ case, you will know that they only pay lip service to the rule of law. The court adjudicated that Section 39(1)(b) of the Legislative Council Ordinance is in contravention of Article 21 of the Borough and also Article 39 of the Basic Law, and the court commented on that section. However, you hit below the belt in that the judge attended to one judicial review, and the judge ruled that that particular section was unconstitutional. However, the judge left you some room for maneuver and you exploited it. You can see that those 2 sections are more or less the same in nature. 39(1)(b) says that if a person has not served that prison term or any penalty that is going to be taking the place of the prison term, and the court reached a final decision to say that this is unconstitutional. But 39(1)(b) does not mention unconstitutionality because the judge was not given the task of looking at that, and he also commented on it, but you hit below the belt.
And then 39(1)(b), you have to change it, and then 39(1)(d), you're not going to do anything about it. Of course, you may wish to take further action, but then you are using this as the basis for public consultation, and you are telling us that you've received 18 submissions. Now, I want to say that electoral rights are sacred and inviolable. Restrictions can only be imposed by the law, provided that the principle of proportionality is complied with. In other words, you have to state the objective, and the restriction must be proportionate to the purpose. Now you are saying that there are 3 objectives: maintaining the public confidence in the electoral, ensuring the proper operation of the electoral, and maintaining public confidence in the electoral process. So, of course, you can apply these to 39(1)(b) and 39(1)(d). Para 9 is the administration's response to the BA's and the Law Society's views. So for for those who are serving sentences, for those who are on bail, why is it that you think 39(1)(b) is unconstitutional and yet 39(1)(d) can be retained? So are you trying? Is it that you have a lot of money, a lot of time, so you are challenging others to go to court to you, or go to court against you again? Right. So why is it that these 2 subsections are to be dealt with separately? Right. Let's have the administration's response first. Now, what is the main difference between the 2? For 39(1)(b), we're talking about those who haven't served their sentences. But for 39(1)(d), they are those who are serving their sentences. So I think there is a difference in treatment is warranted and justified. Concerning those who haven't served their sentences, we in fact received different views in the consultation exercise. And then concerning those who are serving their sentences, whether they should be allowed to stand in the election again, different views were expressed. Now, for those who are serving their sentences, for those who are in prison, previously, they were not allowed to stand in elections. But I have one simple question. I don't want to talk about the principles. I don't want to talk about whether the right to take part in elections is an absolute right provided for in the Constitution. Is it that you are brushing aside the views put forward by the Bar Association and the Law Society? You only adopt their views when those views or suit your purpose. So what if voters know very well that they are serving sentences, then and if voters still choose to elect them, then does that mean that public confidence in electoral cannot be maintained? The answer is no. So the right to take part in elections is very important. The right to be elected is very important. We initiated the de facto referendum, and you decided to deprive us of our rights to stand in elections. And in fact, in this exercise, in fact, you can deal with both subsections at the same time, and the views of the two legal professional bodies are clear. Why is it that you've chosen to brush aside their views and suggestions? All right, your time's up, Ms. Ann Chang. Yes, Chairman, I want to ask one question. In fact, I am referring to Annex 2, B1 and B2. If the judge allows you bail and you are waiting to appeal, then you can stand in an election. And then B2, you are imprisoned, and of course you may still want to appeal, but then you will be disqualified. Is that what you mean? So in the first case, the person will not be disqualified. In the second case, he will be disqualified. Now, if someone is convicted, then whether he is allowed bail or not, there are no clear provisions. Some may say that bail is allowed because the imprisonment term is not too long. But then we've seen cases where the imprisonment term was short, and those people served their sentences and still had not had a chance to lodge appeals. So I think you should be fair to all those who have been convicted. You either allow them to stand in election or you do not allow them to stand in election. Or you may say if someone is convicted and the imprisonment term doesn't exceed 3 months, then you allow them to stand in election, all right? I think for those who are convicted and are waiting for appeal, then I think it's not fair to apply different treatments to them just because one is not in prison physically and the other is. Yes, Under Secretary. Yes, Chairman. So, so we're talking about people waiting for or waiting to appeal, and I think there is a difference between whether he is waiting to appeal outside prison or whether he is waiting for appeal when he is in prison. I think there is a difference, and so we are proposing different treatments. For those who are on bail, they haven't served their sentences yet, then they are allowed to stand in election. But then if they are imprisoned, if they have not been granted bail, then even though they are waiting to appeal, they can't be allowed to stand in elections. But then for those who are convicted, and if they are waiting to appeal, then are they regarded as free persons, so to speak? Now, I think we're not saying that they are free persons. I think the main argument is that this person is not physically in prison, and so if he pays home visits, if he carries out electioneering activities, he is free to do so. And in this way, he is no different from other candidates. Chairman, if a judge doesn't allow a certain person bail, or if he allows a person bail, then do the judges have very clear criteria to go by in deciding whether bail can be allowed? Or is it that a judge is totally free to exercise his discretion as to who can be allowed bail and who have to be imprisoned immediately? Are there any guidelines that the judges need to follow? Are there clear criteria? Legal advisor, there are no such provisions, but then there are clear guidelines in the Court of Appeal for courts under it concerning under what circumstances bail can be allowed for someone who has been convicted, so that he can wait for appeal without having to be imprisoned. Now, one of the guidelines is a very short imprisonment term, and the judge may, in this case, allow bail, and the judge also needs to take into account whether there are merits in the reasons for appeal. Now, if there is little chance that the appeal can be successful, then even if the imprisonment term is short, the person convicted may not be allowed bail. But then when a person is first convicted, he may be convicted at any level of court. Now, say the district court may sentence you to 6 months imprisonment, and the district court judge doesn't have clear criteria to follow in deciding whether that person whether the person needs to be imprisoned immediately or whether that person can be allowed bail. I think the legal advisor has already explained this very clearly. So the administration's position is that if someone who has been convicted is allowed bail, then he can still stand in election. But if he is imprisoned, then he cannot. But some have asked why there is differential treatment. Say 2 persons may be convicted, they may each be sentenced to 6 months imprisonment, but one may is allowed bail, the other has to be imprisoned immediately. But then for the latter, he may succeed in his appeal, and yet he cannot stand in election. And then for the person who has allowed bail, there is also a possibility that his appeal may not succeed. But then he is allowed to stand in election, and as a result, by the time his appeal is quashed, he may already have become a legislative member. And so I'm of the view that there should not be differential treatment for these two types of cases. All right, so this is your view. Mr. Chen Chi-chun, thank you. Chairman, last time I asked a question about a person who breached the laws in another place and was imprisoned in that place. And I'm disappointed with the administration's reply. The reply is simple. Wherever you are in, you have to comply with the laws in that place. So you are assuming that the judicial system and the enforcement of the laws in that place are sound and proper. And also, do you know that some acts are lawful in Hong Kong but not in another jurisdiction? And maybe this place hasn't entered into any agreement with Hong Kong on enforcement of judgments and so forth. So it seems that the administration's justification is that there will be too much trouble. In adopting my proposal, but then I don't think that's a good enough reason. Under Secretary. Yes, Chairman. In fact, Mr. Chen Chi-chun raised this point last time. We considered the issue very prudently and carefully. And we came to the conclusion that one principle was important. And the principle is the principle is this. Mr. Chen is asking whether we can be certain about the soundness of the judicial system in another place. Now, we in Hong Kong are not in a position to judge the soundness of the judicial system in another place or country. And Hong Kong citizens need to comply with the laws of the place that they are in. Similarly, visitors to Hong Kong need to abide by the laws of Hong Kong.
Therefore, we thought about it again, and we thought that it would be more ideal to have consistency on this point. By the same token, Mr. Chen could avail himself to the articles of the Basic Law on disqualification of members. That article sets out that whether you're in Hong Kong or overseas, that article of the Basic Law applies. So the Basic Law already includes that spirit. Mr. Chairman, I know that you said last time that if the jurisdiction of a place is known to be less than ideal, then we should not go there. However, I think you should have special arrangement for this. Can we have a judge in Hong Kong to deal with that if that really happens? And we should not just say if someone is already convicted overseas, even in a less than ideal jurisdiction, we would just adopt it. Under Secretary, do you have any room for maneuver here? Well, what Mr. Chen is proposing is actually quite dangerous. He is saying that we should get a judge to evaluate the situation and juxtapose our laws with the laws in an overseas jurisdiction to see which one is more severe and which one is fairer, and also to come to a view as to whether an overseas judgment is fair. I think that is dangerous. So, Mr. Chen, I hope you will agree with us that we need an objective standard instead of subjective judgments in this system. Any subjective judgment on disqualification will bring more unfairness. I think what is important is that there is consistency and clarity, so there will be no arguments or uncertainty. That is more important. Well, Mr. Chairman, he is saying that we should not argue on it. There is no room for more arguments. And he is saying that the administration stance is if someone has already reached a judgment, we should just abide by it. That's correct, said the chairman. Ms. Emily Lau, chairman, we should listen to the views of the two law professional bodies and also the protection of the public's right to stand in elections. Just now, the Undersecretary said if there is an appeal and the term of imprisonment has not been served, then there could be the right to stand in an election. But if someone is already serving a prison sentence, then he will not have the right to stand in elections. I don't understand that. Why don't you allow someone in prison to stand in election? And also whether he should be given leave to electioneer. Well, I think we can have a second thought because he's after all serving a prison term and he may not be given all the liberty to stand to electioneer. You remember there was this case in North Ireland. Bobby Sands, the IRA, he went on a hunger strike for over 60 days and in prison and he died. But then he won the election. So for certain reasons, a prisoner of conscience may be in jail, but he would be given the right to stand in elections, and so electors could make a choice. Undersecretary, why don't you give us a detailed response to the laws of the two legal professional bodies? Why don't you allow someone who is waiting for an appeal or being imprisoned to have the right to stand in elections? Undersecretary. Chairman, Ms. Lau should understand one point. The right to stand in elections is not an absolute right. Reasonable limitations can be imposed on that right, and that is also true for other jurisdictions. Just now we said that if someone is not serving the prison term, he can do electioneering, he can be in contact with his electors. So we allow him to stand in elections. However, if he is imprisoned, then he should not stand in the election. This is not something new. This has always been the case in Hong Kong. If we are going to change that, then we are afraid that if he engages in election activities, unfairness may result. For example, if a candidate who is a prisoner is allowed to electioneer freely, it may not be fair to other people who are imprisoned. On the other hand, Ms. Lau asked whether we should not allow this person to be freed from prison for a short period of time. Now then, it may not be fair for this person as compared to other candidates who are free to rally for votes. So we don't think this person should be given the right to stand in elections. This is always the case, and we think this is not unreasonable. But Chairman, you are consulting us, and there is a diversity of views. In other words, there are views which are saying that these people should be given the right to stand in elections. So it is not a matter of whether it's reasonable or unreasonable. Since you are consulting people, then you should give this more thought. Well, I understand there may be limitations, but let us discuss it. You say it is not fair to him. Well, I think the biggest unfairness is that you don't allow him to stand in the election. You should allow him to stand in the election, but because he is a prisoner, then he should not be given leave to take part in all the activities he might like to. Well, I think, yes, you can strike a balance there. But if you say, since you don't have the liberty of movement, then you should not be given the right to stand in elections. Now, I cannot agree with that logic. The Law Society doesn't say this is an absolute right, but an important right protected by the Constitution. If you are consulting, you should not argue as if you have already decided on it. You should listen to views of all parties and try to relax the provisions and allow prisoners to stand in election, but maybe his liberty is limited. If he is properly nominated, then electors should have the choice. I thought you are still open. Why do you put it as if this has been decided upon? I agree with Ms. Lau that we are consulting members here. That is really the case. And so other members can also speak up. But I have the duty to let members know our views. Okay, you were explaining the views of the administration. Mr. Leung Kwok-hong, Chairman, I'm very happy because I was the one submitting the case for JR, and I was waiting for an appeal then. And the administration is saying that this will still be allowed. And another point that I argued in court was, if you commit crimes in other jurisdictions, but those crimes are not regarded as crimes in Hong Kong, then could there be a discretion for that person to stand in elections in Hong Kong? I think you should act with care here. People may break the law because of religious beliefs. Say in Hong Kong you can eat pork, you can have wine in a pub. But if you go to Jakarta or other Muslim countries and you are careless and you drink, then you would break the law. You would be detained and also sentenced. And if for that you lose your eligibility to stand in elections, I would ask you to act with caution. And this is about customs and culture. The same goes for political reasons. In Hong Kong, it is all right to march or stage a demonstration, but this is not allowed on the mainland. Say on the mainland, you petition a certain department and you are arrested, you are detained or sentenced. Now, what should you do about that? The law says on the day of application for standing as a candidate, if you are not a free person, then you will not be allowed. Say if I go to the mainland, of course I cannot go to the mainland, but supposing we go to the mainland and we are criminally detained, what happens? I therefore say that you should give careful thought to this. My friend Mr. Lau Shan Cheng was imprisoned for 10 years on the mainland. He could not comply with the ordinary residence in Hong Kong for a number of years, and he took it to the court and he won. He had actually wanted to stay in Hong Kong, but another jurisdiction held him in prison, so he could not be ordinarily resident in Hong Kong to be eligible. However, he won the case and he became eligible in the end. So you should rethink this. I understand you, Mr. Lau. I think it's important to have consistency, or else there will be endless arguments. But I believe the authority should rest with the court. In the law, you can allow the court to deal with this, or else there will be judicial review cases, and the court will be able to declare that the REO is faulted. And I think this is not an ideal situation, because you now place the responsibility on the REO. We have to face this problem together. In other words, someone may be sentenced to imprisonment in another jurisdiction for a crime which is not regarded as a crime in Hong Kong. How come that person should lose his basic right of standing as a candidate? I think you should rethink this, or else you cannot sufficiently deal with this problem. Just take the mainland and Hong Kong. They have a different view on political rights. If someone commits a crime on the mainland, but which is not a crime in Hong Kong, and I can give you this example, the national security law. We don't have Article 23 legislation yet. If we commit a national security crime on the mainland and are detained, and then as a result we cannot stand in an election in Hong Kong. How can that be? Undersecretary. Chairman. I think Mr. Leung's point is quite similar to that one raised by Mr. Raymond Chan. We maintain the view that whether you agree or not, if you are in an overseas jurisdiction, you should comply with the laws there. Coming back to Hong Kong now, Mr. Leung is saying that we should give back the authority to the court to make a judgment. I already pointed out that this might not be appropriate because, most importantly, with regard to the right to stand as a candidate, the law should be objective and clear and precise. I think that is most important. Today we propose to do this so that we have objectivity and consistency. Mr. Leung Yu-chung. Thank you, Chairman. The right to stand in election is a political right. At present, it is still a good situation in that in Hong Kong, we only have crimes under the criminal code, but we cannot be deprived of our political right. So our right to stand in elections should not be deprived of us, even if we commit a criminal offense, whether or not the sentence has been served out. I don't think we should deprive anybody his political right in any way. I think you should allow everybody the right to stand in elections. I think that is the major premise and the most important principle. As for imprisoned people, even if there is an appeal, but if the person is already in prison, then he should not enjoy the right to stand in an election. I think that is a very complicated issue. I hope you will give it more thought.
In fact, people consider different factors in deciding whether to appeal. Maybe the imprisonment term is not long, and as a result, a person may not be released before he or his appeal can be dealt with. So what I'm trying to say is, you can't deprive people of their right, saying that such a right is not absolute. In fact, in my view, this right is an absolute one. So it's important that people be allowed to take part in elections. Or concerning the failure of an imprisoned person to conduct electioneering activities. I think we can discuss this issue further, but that should not be used as a reason to take away people's rights to take part in elections. Now, we don't have laws to take away people's political rights here in Hong Kong, so I think you should tell us how our laws can safeguard people's rights to take part in elections. Yes, Chairman. Yes, I understand that the right to stand in election is a political right that which is very important. So after the judicial review, we decided to propose an amendment. So we are proposing this amendment so that for those who are not serving their sentences yet, who haven't started to serve their sentences yet, they can be allowed to stand in elections. Now, Mr. Leung Yu-chung, I think, has a point in what he said. I want to say that the right to stand in election is not an absolute right. I'm not talking about the right to universal suffrage. I'm talking about the right to stand in election. It's not an absolute right, but then it's a very important right. And so the principle of proportionality is very important here. This point is also made by the two legal professional bodies. So some say that we should look at the length of the imprisonment term. Some say we should look at the nature of the offences. I understand that there are different views in society. In fact, we are still listening to public views. But I don't think this is an unreasonable restriction. Yes, I understand that certain restrictions can be imposed on, say, carrying out electioneering activities. But I think the right to stand in election must not be taken away from these people. What I'm saying is that these people should be allowed to stand in election. It is just that suitable restrictions may be imposed on their activities. Under Secretary. So is Mr. Leung suggesting that these people be allowed to take part or to stand in elections, but then they say cannot be allowed to leave prison to carry out electioneering activities? For example, the campaigning team can help him carry out electioneering activities. But then that would do you think that would be unfair? Because other candidates can carry out electioneering activities, but then I may be ill. I may not be able to carry out the electioneering activities myself. But then my campaigning team can help me. And the constituency is so big, and as a candidate, I won't be able to carry out all the door-to-door visits myself. For example, I have to rely on the assistance of my campaigning team. Ms. Claudia Mo. The administration has said in the paper and also verbally that the right to stand in election is not an absolute right and can be subject to proper and reasonable restrictions. Now say someone is in prison and he is waiting to appeal, and if you say that he cannot satisfy the criterion of loving the country and loving Hong Kong, then he will be regarded as not eligible. And do you regard this restriction as reasonable? Now, in North Island, there was a person who was in prison, and he was elected to be a member of Parliament. But then he died because he staged a hunger strike. Now, you're saying that if we allow an inmate to stand in election, that would be unfair to other inmates. But then the other inmates are not standing in elections, and similarly, you can't say that candidates for elections can make speeches on the streets while other people can only remain silent and stay at home. They haven't chosen, the latter haven't chosen to stand in elections. So, Chairman, we have to be vigilant. Now, because in future there may be political prosecutions, there may be political offenders in the future. Say a very popular political figure may be imprisoned, and he wants to stand in election, and I think our laws must allow that to happen. So please, Under Secretary, do not tell us that a decision has been made and no changes can be made. The world is evolving, the world is progressing. In the UK, those imprisoned were not allowed to be MPs, they were not allowed to assume office, but now the situation has changed. And here, we're only talking about the right to stand in election. Yes, Under Secretary, please. We haven't come to a conclusion. We are still listening to the public's views, and of course, we will very prudently consider all the views received. And I want to say that, in fact, there are divergent views on this issue. Ms. Priscilla Leung, many members are in favor of relaxing this provision, but I think we need to take into account Article 79 of the Basic Law, subparagraph 2 and subparagraph 6. If a member is absent from meetings for 3 consecutive months, then he may no longer be qualified to be a legislative member. And then paragraph 6 is about imprisonment for 1 month or more. So for these 2 subparagraphs, especially paragraph 6, it doesn't really mention any particular types of offenses. Mr. Chim Poo-chong was disqualified because he had to be imprisoned for over 3 months. So how come we have this provision that a member will be disqualified if he or she is absent from meetings for 3 consecutive months? It doesn't say here for what reason he or she has to be absent from meetings for 3 consecutive months. And of course, we have the legislative ordinance. We have to look at the legislative ordinance as well as the constitutional requirement under Article 79 of the Basic Law. Some people are being very imaginative. They think that one day in Hong Kong, some people may be deprived of their political rights. But then, I think in Hong Kong, we will still be following the common law, culture, or convention. But of course, I can't rule out extreme situations, but I don't think those situations will be in a local legislation. And so I think we need to also make reference to the intent behind Article 79 of the Basic Law. And I want to point out that if we relax the criterion, then we may not be able to fulfill the requirements, Article 79. Mr. Wu Chi-wai, thank you. Some people may be convicted in places outside Hong Kong, but in fact those acts are lawful in Hong Kong under Hong Kong laws. Now, for a functional constituency election, there is a committee to look at whether the candidate really has a link with that functional constituency. I mean, if the candidate has any doubt, he can approach that committee for a ruling. And so, can we have a similar mechanism? In other words, that particular committee can look at whether that person who has breached the laws of another place can still be eligible to stand in election in Hong Kong. And then second, we are concerned that restrictions on people's right to stand in elections must not be unreasonable. With regard to the appeal arrangements, is it that the imprisonment term must not exceed 3 months? Because according to para E, this person will not be qualified to stand in elections. So for imprisonment terms less than 3 months, we should mainly be talking about less serious offences. I think when imposing restrictions on people's rights to stand in election, the restrictions must be reasonable. The Undersecretary may say that if this person lodges an appeal, then there will not be unfairness. But then, there is a 2-month gap between the time when a person is nominated and a person is being elected if he succeeds in the election. I think he should still be allowed to stand in elections. But of course, he won't be able to carry out all the electioneering work himself, and then he has to rely heavily on the assistance of his campaigning team. And I think in implementing such an arrangement, you will not be unreasonably depriving these people of their right to stand in election and their right to be elected. Undersecretary, I don't know whether my colleagues may wish to supplement in respect of the second question. So you are saying that for those who are serving imprisonment terms in prison, they should still be allowed to stand in elections, provided that the term of imprisonment is shorter than 3 months. All right. And then those who have committed offense outside Hong Kong, a committee or a judge in Hong Kong should be asked to look at whether this person can still stand in elections in Hong Kong. So that's your suggestion. The law lays down objective standards or criteria as to whether a person is eligible to stand in an election in a particular constituency. So there are objective criteria to go by.
But some members are saying we should get a judge or a person to look into the issue, and that is whether the law in Hong Kong also regards the crime committed overseas as a crime in Hong Kong, and which is more severe, and whether that jurisdiction is fair and proper. Now, that is not as easy as you said. This is not to be objectively decided easily. So to me, if we can still preserve a legal provision, I think that would be clearer and objective, and it would be easily understood by everybody. Ms. Sit-Ho? I'd like to take up where the Undersecretary has left off. Well, indeed, in some Muslim countries, women cannot wear shorts in the streets. They could be stoned to death. Now, if a Hong Kong woman is convicted and she is penalized by caning, does it mean that she cannot come back and stand in elections because people in Hong Kong wear shorts? I think this is easy if you want to write it into the law. As you said, if we have the same crime in Hong Kong, then you can look at the criminal code and to look at the penalty that could be meted out in Hong Kong. You don't need a judge, a chief judge to do it. You can do minor research and you will be able to find the answer. So I agree with Mr. Leung Kwok Hong and Mr. Raymond Chan. You cannot say generally that as long as you have committed a crime in any overseas jurisdiction, you would be disqualified to stand as a candidate in Hong Kong. I think that is wrong. And Chairman, if I look at the consultation paper and also this paper, I fail to see one thing. Maybe I have omitted it, and that is on the day of applying to stand in election and also on voting day, the candidate must present himself. However, if it is a short-term custodian sentence, it is not exactly a sentence, but you have to renew bail, but this is not accepted on the day the bail is renewed, but you are remanded in Lai Chi Kok Detention Center for going to court next week. Now, does it mean that this person will be disqualified? Because the police can decide on the day of bail renewal to say the person should be detained as soon as possible or there and then this person will be disqualified. Don't you have to consider that point more carefully? Ms. Chung. Thank you, Chairman. I'd like to answer this question. If we are not talking about people who have been convicted, in fact, you are referring to people who have not been convicted or sentenced, so they are not subsumed under this ordinance. But what about the existing election laws? Undersecretary, can you clarify this point? Is it that the candidate must present himself on voting day to preserve his candidature? Because what I'm asking is, if we do not change that law, some candidates may be subject to a possibility of sentencing, and then maybe 3 days before voting day, and he is refused for bail renewal and he is put into Lai Chi Kok Detention Center, then would he be disqualified? Chairman, yes, Undersecretary, I'd like to clarify one point. Ms. Ho is talking about someone who has already applied and he is already a candidate. And then at the end of the nomination period, suddenly his bail is not renewed and he is detained. He is not imprisoned, he is detained. And he has no liberty to move around. And what would happen? Chairman, maybe I can defer to the DOJ afterwards. But my understanding is about Ms. Ho's scenario, since that person has not been sentenced yet, his candidature should not be affected. As to whether he needs to present himself on polling day, there is not such a requirement. Maybe the DOJ colleagues can supplement. Who would like to supplement? Ms. Chang. According to 39(1)(d) of the ordinance, it says on polling day or on election day, someone may be imprisoned. But Ms. Ho is talking about people who have not been sentenced but are only in police custody. Reading the law as it is, that person will not lose his candidature. So, okay, thank you for that clarification. Someone will not lose his candidature if he is detained in Lai Chi Kok. This is how we read the law. Okay, Mr. Fernando Zhang. Thank you, Chairman. Under the basic law, apart from Article 79, as mentioned by Ms. Priscilla Leung, and that is in what circumstances LegCo members will lose their qualification, I think we should also look at Article 26 of the basic law. And that is, permanent residents of the Hong Kong SAR shall have the right to vote and the right to stand for election in accordance with law. This is very basic protection. And I cannot see any other articles of the basic law commenting on this right for permanent residents. And I'm talking about the right to vote and the right to stand for election. I cannot see any other limitations on such rights. And Article 39 of the Basic Law says that the provisions of the ICCPR and other conventions of the UN as applied to Hong Kong shall remain in force. Given the spirit of these conventions and also Article 26 of the Basic Law, I cannot see why we need to consider disqualification of candidates with unserved prison sentences. Why should these people be disqualified? I think this is basically problematic, and this may fly in the face of the basic law. There can be different scenarios for unserved prison sentences. The so-called paper is very clear. Some people may be waiting for appeal, and others are lodging an appeal during imprisonment, and the person has to wait for a long time before the appeal is heard, and the imprisonment term may be shorter than the appeal waiting period. In the end, if the person has his appeal allowed, then you will be creating unfairness for this person. And simply put, this is my stance. Mr. Leung was correct. We should not put limitations on people's political rights. Yet here, you are imposing conditions. I think this is unfair. This is unreasonable. I am saying that no matter what the circumstance is, we should refrain from limiting the political rights of Hong Kong PRs. Okay, that is a remark. And now 4 more members would like to have a second round. Anne Chang, Leung Kwok Hong, Wu Chi Wai, and Raymond Wong. We have another agenda item, and we are already 25 minutes behind schedule. We also have Priscilla Leung, 2 minutes each. Since the administration is just consulting members, you can just state your views, and the Undersecretary will consider your views when he goes back. Ms. Anne Chang. Chairman, since the Undersecretary says he is listening to views and nothing has been decided, my views are not the same as Mr. Fernando Cheung's. As long as someone is convicted by the court of first instance, whether or not he is imprisoned, in a certain sense, he has already lost some of his human rights. That, for example, he has to report back at designated time, and also he has to surrender his passport, and he cannot travel outside Hong Kong, etc. So I think there should be consistency. On the other hand, I will look at this from another angle, and that is from the angle of the public. If someone is convicted and is bailed, and if we allow this person to stand in elections, he may lose his appeal, and he may be imprisoned for 3 months or 6 months. If this person is imprisoned, we need to have a by-election. As you know, by-elections are expensive, especially if you are talking about the DCFC2 seat. It can be very costly. For the sake of fairness, therefore, for the sake of fairness to the public, I think the Undersecretary should consider doing this. As long as that person is convicted, even if he is waiting for an appeal outside or inside prison, I am of the view that that person should be disqualified. For your consideration, please. Next, Leung Kwok Hong, Chairman. Now, what is the issue? If a electoral member should be disqualified, that is regulated by Article 79 of the Basic Law. I was subject to such sanction, but in the end, I was not disqualified. Now, if you say someone is convicted and the person should not be able to stand in elections, the biggest point is about uncertainty. Of course, if the prison term is for 10 years, then that person should not be a member. Well, you can disqualify him under Article 79. You should not preempt the situation. If the election is such that the electors give the mandate to a person to represent them, then you should not deprive electors of that right. that person may be elected, but he may not be able to discharge his duties, then he can remove him under Article 79. When the domestic law is written, we did not have Article 79, so it is outdated. I will say again, if elections are for the public to elect their political representative to Parliament, then that person should be able to be elected. And if he cannot discharge his duties, then the Parliament should be able to disqualify him. As I said, the prison term may be for 10 years. You allow me to stand in elections, but then the colleagues in Parliament will say, look, this person cannot discharge his duties, so let us dismiss him. There is the mechanism to do it. So I think your thinking is incorrect. Election is a kind of political mandate. You should not deprive people of this political mandate. You cannot dismiss it for the sake of uncertainty and for saving money. This is a matter of political theory. We should be fair to legislative members. Okay, next, Mr. Wu Chi-wai. Thank you, Chairman. 2 points. 1, I'd like to inquire about certain matters. Are we talking about an imprisonment term of 3 months? According to 39(1)(e), if it is over 3 months, then that person will automatically lose his qualification. Can I have some confirmation about this point? Secondly, the assessment of qualification for standing in election, according to 37(2)(b), the wording is very simple, that you have to satisfy the presiding officer that he has a close liaison with that sector. It is not a very exact concept. If that's the case, we can take reference from members that we should make that concept clearer. Because as a matter of fact, as long as candidature for functional constituencies is concerned, you use the term a close liaison. I think that is a very loose term. Under Secretary, we will take the second point back for consideration.
And Ms. Chong, can you answer the first point? Thank you. Concerning the point about 3 months, Section 39(1)(e) says that within 5 years, within a 5-year period, if there is an imprisonment term of 3 months or more, and then if there are certain specified offences which have been committed, for example, offences under the POBO and the other relevant ordinances, then the right to stand in election will be taken away for 5 years. But then for 39(1)(e), our proposal is that if a person lodges an appeal and if at a time he is not in prison, then there will be a mechanism to suspend the disqualification. Mr. Wong Yok Man, I want to emphasize that these restrictions are in no way linked to the discharge of duties. We need to protect people's rights to stand in election. Of course, you have to amend 39(1)(b) because there is Leung Kwok Hong's case, and then but then you are not amending 39(1)(d) at the same time. You have brushed aside the views of the two professional or legal professional bodies. Of course, you will say we are still in a stage of consultation, and we may adopt the comments made by the two legal professional bodies. Mr. Leung Kwok, why have you really studied all the materials? Now, in fact, there is already 79, as mentioned by Leung Kwok Hong. If you don't come for meetings for 3 consecutive months, you'll be disqualified. And then concerning imprisonment, of course, N. Chang also said that we should be fired. But then, of course, the motion was not carried in the whole council. So there is a mechanism to deal with these cases. this is an opportunity for you to correct the wrongs. Why are you not doing it? All right. The NPCSC's decision made on the 31st of August cannot be changed. But what about this present mechanism? In fact, you are fully capable of doing something to perfect the system, and so I think it's a waste of time telling us that you will be listening to our views and reflecting them to the NPCSC. Ms. Priscilla Leung, I think Article 26 and Article 26 and 79 have to be looked at side by side and together, not in isolation. Let's look at the legislative intent behind Article 79. Under paragraph 6, a member may be fired if he is sentenced to imprisonment for 1 month or more for a criminal offense. I think the restrictions are reasonable. We talk about our own laws, and also we have to also take into account Article 79. I think the present arrangements are reasonable. It doesn't mean that so long as there are restrictions that would be a violation of Article 26. We can't just look at Article 26 in isolation. You have to look at Article 26 together with other articles. Thank you. All right. Right, a lot of views have been expressed. So the Undersecretary, I'm sure, will consider all these views. And will you come back to this panel, or will you proceed to work on the amendments to the legislation? Yes, we'll respond as soon as possible. I think the suggestions made by members today are very useful, and we will be preparing the amendments. All right, so you have to come back to us anyway. Item 4 on the agenda, consideration of the third report of the Hong Kong SAR under the Convention on the Elimination of All Forms of Discrimination Against Women. So let's invite the administration in.
由於我哋上一個議程呢就傾得長咗，咁啊，所以呢。
Now, as we overran under item 3, we have to be concise when we discuss item 4. We have over 10 officials attending for the discussion of this item. I'll not be introducing them to members. We have 2 papers, CB2267-05, a paper by the administration, and then we've got paper 267-06, LegCo Secretariat background brief. So, Ms. Tan, do you need to take us through the paper? Do you need to do so? It's up to her to decide. Do you think you need to take us through the paper? If you think this is not necessary, then we'll proceed to a Q&A. Yes, Chairman. In fact, we submitted a third report to the UN committee. And last week, we issued a press release, and all the relevant documents have been uploaded onto our website. So want to, we can proceed directly to Q&A. 5 members, Wong Yok Man, Sin Chong Kai, Helena Wong, Anne Chang, and Emily Lau. So 4 minutes for each member. Mr. Wong Yok Man, thank you. The administration treats the UN committee as if it were the LegCo, and so it goes round in circles in the report to the committee. It gives irrelevant replies to questions raised. In fact, some issues were raised when the first and the second reports were submitted, but the problems are still there. For example, trafficking in women, and also protection of sex workers. Now, we don't have a set of comprehensive laws on this, and we don't have laws defining what sex establishments are. It is said that there is already the convention, the international convention. So it seems that you like to keep repeating yourself. Why is it that the convention is not extended to Hong Kong? And then it is said in the report that the law enforcement agencies in Hong Kong have been working very hard and have been enforcing the law rigorously. Then it is said that prostitution is not an offense in itself, and then there are laws to protect people from being exploited and to minimize nuisances caused by prostitution to people's livelihood. So is this nonsense? The answer is yes. Have you really responded to the questions raised by the committee concerning trafficking, the trafficking problem, and also exploitation of sex workers? You haven't really given pertinent replies, so you are going around in circles. Is it because our officials have not received any training in liberal studies, or is it that our officials consider or regard the UN committee members as idiots? You know, look at the functional constituencies. How many female members are there? And this is discriminatory against women concerning low participation rate in political affairs on the part of females. Yes, we have a chairman of the DP who is a female, and then of course we have Miss Anne Chang, a female. And then there was a bill which was not passed. That was the marriage amendment bill, and that in June 2013 there was the Sexual Minority Forum set up, but then that forum has not been operating effectively. So how can you still claim that you are working very hard to eliminate discrimination under CEDAW? So you treat the UN Convention as if it were a LegCo panel. You keep repeating yourselves. You take people around in circles. You repeat the same stuff. So I think this is really this is really very disgraceful. Mr. Sin Chong Kai. Yes, Chairman, thank you. Your press release says that the legal framework is extremely rigorous. People are criticizing us for not having a set or a comprehensive set of legislation. Now, we may not have a piece of anti-trafficking legislation, but can we allay their worries by citing the relevant provisions in different pieces of legislation to protect women against trafficking? You can't just take the committee members round in circles. Are there existing provisions to prevent trafficking? And you can also tell the UN committee how many arrests have been made, how many cases of prosecution there have been. So you can't simply say that we have a very vigorous legal basis on or things like that. Yes, Permanent Secretary. In fact, we fully respect the UN mechanism, Chairman. In fact, in the conclusions, in its conclusions, the UN committee said that we had submitted a report in accordance with the guidelines, and in fact, we provided a response to the questions raised by the committee members. At the hearing, we were not given really a lot of time to respond, but then we impress upon the UN committee that we didn't really have a single piece of legislation to deal with trafficking. The provisions, in fact, were scattered among different pieces of legislation. We explained that we had a dense population and we had difficulties allowing certain groups of females to reside in Hong Kong permanently. And my colleague, I think, can supplement concerning the explanations we gave to the committee. So why is it that despite your explanations, the committee has still made this comment? Chairman, the UN said that we should consider giving effect to the Palermo Convention. But then we explained at the committee that we had a huge population. Hong Kong was a densely populated place. And if people have to stay in Hong Kong permanently after they had worked, there would be difficulties on our part.
So we have to act with care. Of course, the UN would still like us to consider their view and we respect it. Maybe I can ask Ms. Wong to explain the relevant laws to say why we have a comprehensive legislative framework. Ms. Wong from SB. Thank you. We don't have a single piece of legislation to ban human trafficking and also the areas covered by the Palermo Protocol. However, we have many local laws to ban the same act. For example, the Criminal Offences Ordinance, the Offences Against the Person Ordinance, and the Immigration Ordinance. And the imprisonment under these ordinances can stretch from 10 years to life imprisonment. And we were also asked about the prosecution figures. In the past 3 years, we prosecuted 5 syndicates, and the longest prison sentence meted out was 30 months. Dr. Helena Wong, on FCs. Paragraph 59B of the CEDAW report. It is said the administration should consider FC's impact on women participation in politics. I think it's a waste of breath to talk about a study because it's already very clear, as mentioned by a member. FCs are really unfair to women because if you rely on occupation to limit people's right to stand in elections, it will automatically be unfair for women because all housewives will automatically be screened out. Some people said we could add women's groups to FCs, but you cannot redress that unfairness. I think what the administration has to do is not to study into the impact. Rather, you should abolish all electrical FCs or reduce their number by 2016. You should at least try to reform it in 2016. Why would you write this report and you said you needed change anything about FCs in 2016 in your report to the NPC. You are taking a leading role to discriminate against women and their participation right in politics. I don't know whether you have CMA Bureau people here. You should seek a change immediately. You should not drag your feet. You should tell me that FCs will be reduced in number by 2016, and there would be no FCs when we have universal suffrage to return LegCo members. Then para 62, paternity leave. In the end, we have a legislation for 3-day paternity leave. We were talking to people in other countries and we became the laughing stock. I already mentioned an amendment to lengthen it to 7 days, and yet you pay people 4/5 of their salary. On the one hand, you say population is aging, no one is having children, but why don't you accept amendments by members? I don't know why you are dragging your feet with that piece of legislation. And also maternity leave. We were criticized that all these years we still only give 10 weeks of maternity leave, and again women are paid only 4/5 of their wages. This is way away from the ILO international standard. In the year 2000, the ILO reviewed the world standard, and in the year 2000 it is proposed that all countries should respect women, pregnant women, children and babies, and the maternity leave should not be less than 14 weeks. But we only have 10 weeks maternity leave in Hong Kong. Why have we not done a review? I don't know whether you have any intention to review it. I also said that even for paternity leave, men should be paid their full wages, because I'm of the view that women should have full wages and also 14 weeks as maternity leave. P.S. Please be precise and concise. I remember at the UN, a Finland representative and some other experts said that they were aware that Hong Kong does not give 14 weeks of maternity leave, but they are also aware that the maternity leave costs would totally be borne by employers. So they understand that the maternity leave could be 10 weeks, but then maybe employees should also take out some insurance. And I explained then, if in Hong Kong we should have employees also to take out insurance for maternity leave, I said that we must act with caution. And so the Finland expert said that he or she would agree that we should again reconsider it. As for the paternity leave, we told them that the bill is with LegCo, and we are waiting for LegCo to resume the legislative process so we can carry the legislation for paternity leave. I don't know whether we can have an answer for FCs. Sorry, no time. Ms. Ann Chang. Thank you, Chairman. Talking about paternity leave, in fact, I am quite irritated about this, and yet Helena Wong is still mentioning it. We have discussed it for over 10 years, and now we have 3 days. Why don't you pocket it first? And then suddenly Dr. Helena Wong says she wants 7 days. Frankly speaking, you want them to go back to the Labour Advisory Board. Are you going to ask the public to wait another 10 years? Well, you can say 70 days if you want, but does it work? Will it be passed? Originally, order please. Order please. Chairman, this is my speaking time. I have already stopped them. I thank you very much. So, if this is not passed and come January 2015, if new fathers do not have paternity leave, then you should take Dr. Helena Wong of the DP to task. And after reading this report, especially the part on domestic violence, I felt very sad. Recently in Kowloon City, a man chopped his wife and his child. The child is seriously injured and he is in a critical condition. The district councillor concerned asked me to find time to give assistance. Indeed, I don't know what I can do, but I have met that family. And is it that we should do much more in this respect? I hope the administration will pay more attention. And last time, the UN commented that the prosecution rate of domestic violence cases is low in Hong Kong. Have you done a review? We said that we have been saying there is zero tolerance for domestic violence. But have we reduced the incidences of DV and have we increased the prosecution rate? P.S. Thank you, Ms. Chang. Yes, it is very sad to see any kind of domestic violence. This is not the same as other cases of violence because the perpetrator and the victims are people of the same family. We understand that we need to do something special to deal with DV, and I would ask Mr. Fong of the SWD to answer the concrete questions, but I can tell Ms. Ann Chang that last time and the time before last, we provided supplementary information and also concrete figures on prosecution to the UN. Mr. Fong, SWD. Thank you, Chairman. We placed emphasis on DV in the SWD. And we did it from three aspects: prevention, professional intervention, and post-case counseling. We have increased manpower and resources all these years for DV. We took care of victims. And in the last few years, we also stepped up our care for perpetrators, male or female. In the last 3 years, we have been developing services for female perpetrators. As for civic education, Ms. Chang mentioned a special case. That case was not subject to any previous record, but through public education, we hope people should be able to detect signs of DV and support one another, and also refer cases for professional help at an early stage. We have 65 integrated family service centers in Hong Kong and 2 family service teams, and also 11 professional social work teams providing round-the-clock service. As Ms. Chang was saying, one DV case is one case too many. And after that case happened, we tried to give assistance to the perpetrator, the victims, as soon as possible, and also actively follow up on education for that community. Next, Ms. Emily Lau. Thank you. Last week, I attended the CDAW committee hearing together with the PS. The committee was concerned about Hong Kong, about maternity and paternity leave. The committee said that our situation is worse than that on the mainland and we are not complying with international standards. And they said there should be flexible working hours instead of just having the paternity leave, and to allow men to understand that they also have a duty to take care of their children and not dump the entire responsibility on women. I hope you will follow up and do whatever you can. As for what Ms. Chang said, I hope LegCo can agree on the figure and pass a paternity leave arrangement which is in compliance with international standard to benefit the public. My question has to do with FDH. The PS would know that the committee is very concerned about foreign domestic helpers who should be protected from discrimination and different kinds of exploitation, especially by employment agencies. Also, the 2-week rule and the live-in requirement. How are you going to respond to those? Who will take the question? Chairman. I said at the UN hearing, I was given 10 minutes and I particularly commented on women employment and also FDH. Ms. Lau talked about flexible working hours and women who would like to work and how they are helped. I mentioned we provided care for children and the elderly, and I also commented on FDH. We have legal protection for them, and secondly, we have strict law enforcement if FDH make reports of exploitation to us. And number 3, we would also like to step up our control on employment agencies. We hope the FDH and the exporting countries can also enhance their awareness, and we would like to work with them so FDH will not be ill-treated. As for the 2-week rule and the live-in requirement, I have explained why FDH have to live with their employers. This is the consideration behind the import of labor, and also the 2-week rule after termination of contract. We explained that this was not a period for them to find work, but some arrangement for them to leave Hong Kong. Maybe Mr. Chen of LD can explain. No, I'd like you to explain how you are going to deal with the employment agencies. The FDH cannot get help from them. Are you going to legislate to regulate them? Can I ask Mr. Chen to let you know what we have in mind? Mr. Chen of LD, thank you.
Concerning the agencies, we stepped up our work in the past year. Some foreign domestic helpers said that they were not aware of their rights. So NGOs gave them information upon their arrival, and they were given a card on the contact telephone numbers of different government departments. And we have been stepping up liaison with the relevant countries exporting FDH to Hong Kong. And so they have said that in the FDH training schools in their respective home countries, they played videos to the trainees concerning how they could seek assistance in Hong Kong and what their basic rights were. Foreign consulates in Hong Kong to organize activities for these foreign domestic helpers and disseminate to them all the important messages. We've also increased our inspections. Previously, we had about 1,300 inspections every year. We now want to increase that to 1,800. So we have regular inspections as well as surprise inspections. This is to make sure that the agents or the intermediaries act in accordance to the law. And we've also issued a code of practice to the agencies. We've reminded them that they must not deduct the wages of the FDH and All right. In fact, the meeting should have ended at 4:30 p.m. But then there are 6 more members who would like to ask questions. And even if I exercise my discretion to extend the meeting by 15 minutes, there still won't be sufficient time for all the 6 members. So my decision is that the 6 members will ask their questions and then we can adjourn the meeting. So first of all, Fernando Cheung. Yes, Chairman, thank you. May I refer to para 11 of the UN report? It is about the implementation of the convention in Hong Kong. It says that in fact there isn't a code of practice to facilitate the implementation of CEDAW in Hong Kong and to serve as clear reference for the courts. I will not repeat the content of para 11. The suggestion is that Hong Kong should come up with a code of practice to facilitate the implementation of CEDAW. So will the SAR government be doing this? In fact, the UN committee has been asking us to do this. So will you be doing it? And then para 55 says that the UN committee wants Hong Kong to, as soon as possible, adopt the recommendation of the LRC to improve upon our laws to protect children and the mentally capacitated from sex assault. And it is also proposed that the definition of rape be amended. Right, so the LRC report was published a long time ago. Are you willing to adopt the recommendations of the LRC? And then domestic violence. Our worry is that there is a lack of a one-stop service for those who need help. Previously, there was a one-stop service, but it was abolished. So will you reinstate a one-stop service? And then education, or rather employment. Some say that in Hong Kong we should scrap the 4-woman-8 arrangement. So what is your response? Yes, Chairman. Para 11 is on the report of the PRC, and Hong Kong is of course a part of the PRC. So in Hong Kong, we are a common law jurisdiction, and so we implement the CEDAW through various means. We have legislation in place, not one piece of legislation. We have 4 ordinances on anti-discrimination matters, and we also have the crimes ordinance and other pieces of legislation, and we also have administrative arrangements to give effect to the CEDAW. So in our 3 reports to the UN committee, we state very clearly that we have been trying to implement the various articles in CEDAW using different pieces of legislation. And then LRC, may I refer to para 9 of our press release. We are following up on the LRC's recommendations in this regard. Next, domestic violence. In fact, we do give a lot of details in each and every report concerning domestic violence. So I don't think the situation has deteriorated. And in fact, as there isn't sufficient time, I really can't invite Mr. Fong to talk about arrangements or institutions like the Rain Lily. Chairman. So it seems that the administration is not prepared to make any improvements. The paper merely gives an account of the present situation. I want to say that female participation in political and public life is very low. It is not because women in Hong Kong are weaker, but you can see that in this council, for example, most of the members are males, and in the traditional FCs, in the 30 traditional FCs, no female member was elected. And for GC elections, we had 9. So about 25%. But if you look at all the traditional functional constituencies, and we only have a rate of 16%. This is really an ultra low level of representation, or ultra low level representation. I think it's true that I am an FC member, but I still think that this problem has to be resolved. I think we have to deal with this issue in the context of our political and constitutional reforms. Then second, the UN Committee wants to see a commission with the authority and the resources to deal with women's interests. The Women's Commission at the moment is under the Labor and Welfare Bureau. It doesn't really have substantive powers. It doesn't have a lot of resources. I believe the UN Committee has in mind a Women's Commission comparable to our EOC. I understand that our Women's Commission is a far cry from the EOC in terms of the resources it can deploy and the authority that it has. Permanent Secretary. Yes, Chairman. The Women's Commission is an important commission under the Labor and Welfare Bureau, Chairman. The UN Committee, in fact, recommended that a Women's Commission be set up, and as a result, the Women's Commission was set up under the Bureau. And we do not want the Women's Commission to duplicate the work and the functions of the EOC. The Women's Commission is a statutory body, or rather the EOC is a statutory body, and its functions are clearly stated in our anti-discrimination laws. But then the Women's Commission is a high-level advisory commission on women's affairs. It seeks to create an environment conducive to the development of women, and second, it is concerned about the empowerment of women, and third, it makes sure that women can enjoy equal education opportunities. There are over 20 members who are not from the government, and then there are 3 official members, and so there is broad representation in the Women's Commission. The Women's Commission also launches various projects, and the Commission has resources to carry out annual programs together with NGOs. So every year we allocate resources to the Commission. So we try to achieve savings within the Bureau's envelope so that the Women's Commission will have the resources to operate its programs. We do require bureaus to follow up on the Women's Commission's recommendations, notably gender mainstreaming and also female participation in advisory bodies. We have already told the UN Committee that we, in fact, have been actively pursuing these issues. So we attach great importance to the recommendations made by the Women's Commission. Ms. Chen Yun-han. Yes, thank you. I wish to respond. Yes, I think Mr. Ip Kin Yuen has pointed out a real problem. And I think another problem is the employment of women. And of course, another concern is the participation of women in political and public affairs. Because of gender stereotypes, women take care of the families and men work in society. In fact, I have already said many times the difficulties encountered by females in employment. And in fact, I've given a report to Carrie Lam on how to enable females to work in society. The greatest problem is the lack of childcare services. This situation has been going on for decades. And then domestic violence. I understand that in this session, we will reactivate the subcommittee on domestic violence under the Welfare Services panel. I think the situation has deteriorated. In fact, very often the police, or rather, and 4 or 5 other departments jointly deal with one single domestic violence case. And they have different separate functions. Rain Lily was a one-stop service. Do you understand that domestic violence victims do need a one-stop service? But then now we have 5 centers instead of 1. I have recently criticized the administration for having turned a deaf ear to good suggestions from the public. Does the administration know that traditions of society and gender stereotypes have made it difficult for women to take up employment? And then for domestic violence, why is it that Rain Lily was abolished? Why is it that the situation has deteriorated?
Because of time constraint, just give me a short answer because I have another question on paternity leave. Give me a short answer and I will ask you again. We fully understand Ms. Chan's concern. In my 10-minute speech at UN, we said that the government will have to take a series of measures to promote women employment, for example, overall planning and childcare services. Well, it's no use paying lip service to it. Let me know the concrete measures. If you think that talking about it amounts to doing it, it's not going to help. If you have already done so, Mr. Ip Kin Yuen will not have mentioned it, and also the community will not continue to give you views on women employment. Yes, we understand. We are not saying that by talking about it we have done it. We are studying into the views you gave us. We hope there could be improvement measures that we can bring back for you. I'd like to give you some figures. Let us look at nearby economies. Our women employment rate is the lowest, 68.3%, but other people have 70%, 80%, and I can mention Scandinavian countries and other countries. In my submission to Carrie Lam, I told the administration of such examples and how women's labor can be released. Please do not think inside the box. You have not been able to resolve the issue over a few decades. And I like to say that the Commission on Women has been fought for by the community. But what you are doing is something quite different from what we asked for. I know you need to do gender mainstreaming, but you have to help women poverty and how women can fare better in the community. Okay, next one. Mr. Lee Chak-yan, Mr. Ip Kim-yun mentioned a very important issue, and that is there is zero women participation in FCs. But Ms. Chen Yun-han has made it out to mean employment inequality. That is correct also, but within political realms, I think there is even more inequality vis-a-vis women participation. I think women have been even more suppressed. As we can see, there is zero participation in FCs. I hope you can give me another figure. Within the 1,200 people in the election committee, how many are women? There will be the nomination committee to be composed of the 4 subsectors. Again, women's political rights are to be suppressed. This is the first question. Secondly, if you look at the UN report, the wording they use is they would like to repeat and reiterate. This is because they have said so many times. They always say recall and reiterate. This is because they have been saying the same things for many years, and yet the administration did nothing. The administration is quite perfunctory towards the UN. You are quite laid back in your responses. And you have not said that you would adopt any of the recommendations of the UN. Which one will you adopt? For example, you would just say you give it serious consideration. Say, for example, maternity leave. There is a difference of 10 weeks and 14 weeks. Will you do something about it? You are not going to do anything. And then paternity leave. There will just be 3 days. Ms. Anne Chang distorted Helena Wong's view and said that if you cannot get paternity leave, you should chase up Helena Wong. I think that is gross misrepresentation. And the administration has already said that there was no hope of getting paternity leave passed before the summer. So why should you chase up Dr. Helena Wong? And the administration has said that it has done its paces and it has gone through the LAB. So you should go to Matthew Cheung if you don't have paternity leave. And if we cannot have 7 days, but only 3 days, you should chase up Miss Anne Chang. She is a woman. She claims to say that men should take up more housework, and yet she objects to providing 7 days paternity leave. Number 3, FDH. Ms. Tam said she would step up control and regulation. But there was the Riviana case, and you said you would step up control, but I could not see anything being reported back to the manpower panel. And also, again, the UN mentioned the same things about FDH. Which one would you adopt? P.S. I would give a quick response, Mr. Lee. On paternity and maternity leave, I think I have already said that at the UN hearing, we explained to their experts the actual situation in Hong Kong. They said that hopefully paternity leave could be passed, so there would be a basis for providing statutory leave to men. As for regulation of FDH, Mr. Chan said repeatedly that indeed we have stepped up control on FDH, and he has explained the measures that are being taken. Now, if you'd like to discuss anything at the manpower panel, we would certainly be responsive, and we would like to find a time to discuss that. Dr. K.K. Kwok. I find the responses of the PS very regrettable. Every year, we revisit the same issues without solutions. In 2013, DV cases have increased by 36% upon 2012. I think you have actually regressed. And on employment, if you cannot provide support services, for example, childcare services, you are just paying lip service to boosting women employment rate. But then I need you to answer two questions. One, village houses. That is the small house policy. It is very controversial, of course. That is the hereditary rights of small houses. The UN mentioned it many times, but what is your response? Village women do not have any entitlement to small houses. If you are going to scrap it for all indigenous villages, I think that would not be controversial. But even today, only men have that right and women don't. That is very unfair. And what have you done? Number two, political participation. If FCs are based on occupations, it is bound to be unfair. You understand that many women cannot take up a job and look after the family at the same time. The only solution is genuine universal suffrage. P.S. Doesn't the government have this responsibility to make sure that the constitutional development reform would comply with the CEDAW and scrap FCs so that whether women have a particular occupation, they have the same political rights? P.S. Thank you, Chairman. I think I said time and again that we are very concerned about DV. No, I did not ask you that question. I asked those two questions, small houses and political participation. On small houses, I think you know that it was a policy made in 1972. It was formulated for anti-indigenous villages. The Development Bureau said that it conducts a continuous review on the small house policy, but there are legal issues, land use issues, and also town planning issues involved. The Development Bureau has told us that it is continuously reviewing the policy. In other words, it has done nothing for 40 years and is not going to do anything from now on. Well, to be fair, there is a continuous review on small houses. Procedures and arrangements have been improved. Compared to 1972, I think a lot of improvement has been made, and we have got the court's comments and other people's views, and relevant improvements have been made. What about political rights? As for women's participation in politics, we always attach importance to it. And at the UN hearing, we have said that women should be able to work and take part in politics, and we are trying our best to facilitate it. As for employment, women should be able to take up any jobs they like and enjoy promotion. We are promoting it. The UN experts told us that they could see improvement in different sectors and jobs, and that women now can go to higher ranks. And hopefully, women can excel in their own trade, and so they will have a bigger chance to take part in politics. Well, she did not answer me this question, and that is FCs which are based on occupation would be discriminatory. You need to abolish FCs. Because in universal suffrage, we do not distinguish between the genders. I'm asking you whether that will be your government's objective, that you would promote equal political rights through universal suffrage. Because of time constraint, please be very brief. Can I ask Mr. Zheng to answer? Yes. In Hong Kong, men and women have the same right in political participation, including participation in FCs. This is safeguarded by the basic law. In the political rights provisions, there is no discrimination between the genders. The one member asked how many women there are in the election committee. It was formed in 2012. including 180 women, or 71 more than the last term of election committee. Mr. Raymond Chan, I'd like to talk about measures to protect sex workers. The UN is very clear in its report that in certain laws there is some constraints, so sex workers work alone, they are tortured, they are subject to violence, and they are exploited. So theirs is a high-risk job. The administration answered two things, but which are quite useless. One, that police would distribute pamphlets to sex workers to teach them how they can protect themselves. Number two, sex workers are encouraged to install alarm systems. But in fact, you know that the UN is asking you about the one prostitute apartments, or OPAs in Hong Kong. Will you respond to that? The UN is saying that the laws do not protect sex workers because they are made to work alone, and that is why they are exposed to danger. Number two, in fact, the people who bully sex workers are not just their customers. The police are also the bullies. Many sex workers have reflected that the police scold them, beat them, or also in covert operations, the police would enjoy the sex service without paying. So it is not just the customers who bully the sex workers. I'd like to ask the SB for figures. Have you got reports of policemen not paying for sex services in covert operations? I'm not asking for the prosecution or successful prosecution cases because they are in the papers. I'm asking for the number of reports. Thank you. In our report to the UN, we said in detail that in terms of legal arrangements to protect sex workers, especially on the definition of vice establishments, we'd like to try to balance a few things. Number one, the privacy of sex workers and whether they are exploited by some groups and also nuisance caused to others. We have struck a balance. We believe the present definition is appropriate. Of course, we will keep watch of the situation and what we should do when we try to balance the three things. So you think you are not going to do a review? Well, we think we have struck the balance, and we think the present arrangement cannot be seen to be inappropriate. As for the police, whether the situation you painted would arise, well, in fact, the police have very strict internal rules. I can defer to Ms. Wong to explain to you the internal arrangements for the police, so to reassure you. Ms. Wong from SB.
As the Permanent Secretary has pointed out, Chairman, the police attach great importance to the conduct of police officers. For those on covert operations, they can be bodily contact only when there is an absolute need to do so for the sake of the operation. And in fact, we do have officers to carry out undercover operations to detect irregularities. Right, the last member, Mr. Leung. Chairman, it's very simple. They say that the legislative or legal framework is comprehensive. I think the framework is restrictive. I think the legislative or the legal framework is restricting what you can do. In fact, it's simple. You just give us a table. Are there rights in other developed countries, but not found in Hong Kong? I'm of course talking about developed countries. And say, are there places where their paternity leave is longer, where the arrangements are more relaxed? So do your homework, and then you can come up with a roadmap. And if there are things that you think you can't achieve in the near future, then you can come up with a timetable. And if there's a roadmap, then a task force can be set up to try to implement the proposals. In fact, members have asked about functional constituencies. Mr. Leung said that there was no discrimination. Of course, there is no discrimination. But then FCs use employment or the occupation as the basis, but then many women are not professionals because they didn't receive too much education, and as a result, it's difficult for them to be elected. So do you get the point? This should not be allowed to happen when there is equal and universal suffrage. In fact, in many of the functional constituencies, there are far more male voters than female voters. In GCs, for example, we don't have such a big disparity. And out of the 1,200 election committee members, only about 15% are females. So how can you rectify the situation? We don't know. No, I think you have to know the problem and then act. But it seems that you are not aware of the problem. And concerning inheritance, the right of inheritance, are you giving women the same rights? Or are you telling us that in 1972 we followed the laws of the Qing dynasty, and so women cannot enjoy the right of inheritance? Women are being discriminated against. What are you going to do about this? Can you give us a table of the things that others have done, but we haven't, and also where the arrangements in other places are more generous than ours? Yes, please be concise. Concerning maternity leave and paternity leave, we have been observing what is being done in other places. And in some places, for example, and in fact, as pointed out by the UN committee, in some places, the leave is not wholly funded by the employers. In those places, there are insurance systems. We have been reviewing the Hong Kong situation. In Hong Kong, the leave is paid for wholly by the employers. So if we are to make a comparison, we have to do it comprehensively and thoroughly. And so concerning the paternity leave and maternity leave arrangements in Hong Kong, I want to say that we have looked at the situation in other places, and we have been comparing the Hong Kong situation with those situations. And then the employment of women. In fact, we said in the UN that concerning receiving of education, receiving of training, changing of jobs, promotion prospects, we've seen improvement. And we hope that women can or will be able to get higher level jobs, and both in terms of quality and quantity. And just now, I was not talking about the right of inheritance. I was addressing the issue of small houses. In fact, concerning inheritance rights, our laws prevent any sort of discrimination against women. All right, time's up. Item 5 on the agenda, AOB, date of next meeting, 15th of December 2:30. As we have more than one item or one more item, we have to extend the meeting time till 5 p.m. One more item. Which item? The report on public sentiments with regard to the NPSC's decision. Thank you.